Hello my dear friends and welcome to StudyIQ. I am Joy and today in this lecture we will discuss about death penalty in India and judicial errors in death penalty. So we will come to the current affair first. Recently the Supreme Court of India had recalled a decision the Supreme Court itself made in 2009 that in 2009 the Supreme Court had sentenced 6 convicts to death and now it has reviewed its order and now Supreme Court has acquitted them. So based on this, we will understand the status of death penalty in India and what are the issues involved and how judiciary can make errors in death penalty cases and how it is going to impact the law and order system in the country. So before we begin, this is our channel StudyIQ and we are providing pen drive courses for various competitive examinations including SSC bank courses, UPSC optionals, SSC JEE courses, teaching examination, railway examination, defense examination, RBI grade B, NABARD grade A, UGC NET, UPSC Civil Services Examination, CLAT exams for various state PSCs and also for various professional courses. You can visit our website www.studyiq.com for more details or you can call to any of these numbers for more information. Now let us come to the topic. Let us first understand what is the case. So as I mentioned in the beginning, the Supreme Court of India, that is the apex court of the country itself, has reviewed a sentence or recalled its own sentence it had passed in 2009 sentencing 6 convicts to death. Now the Supreme Court has recalled the decision and acquitted 6 of the convicts. Now this is an error from the part of judiciary. The Supreme Court would not have been able to revoke this decision if the death penalty was imposed on the 6 convicts. So based on this, we will understand how death penalty in India can cause judicial errors and there is no scope for revocation in case of any judicial errors in case of a death penalty. So first we will understand what was the recent case. So coming to the details of the recent case. The recent case involved the murder of 5 persons and between the periods 2003 to 2009, that is within a period of 6 years, 3 courts. First, the Nasik Sessions Court, the Mumbai High Court and the Supreme Court. So 3 courts had found these offenders guilty and sentenced them to death. And now in 2019, the Supreme Court had undertaken a review for this case. So in 2019, the Supreme Court has revised or reviewed its own verdict and Supreme Court had taken a closer look into the evidences and now Supreme Court have acquitted them or set them free. And in this regard, the Supreme Court also ordered an inquiry against the investigating officer for framing the 6 men. Now what is the biggest issue here? These 6 people who were convicted earlier, they had spent almost 16 years in jail. So they were imprisoned for almost 16 years. And now after 16 years, the Supreme Court have acquitted them and they have been released out of the prison. Now here the major issue is that they have spent almost 16 years in the prison and this is just because of a judicial error. So this is against the law and order system of Indian judiciary. Now this is briefly about the case. Now coming to how death penalty has been viewed in India. India has death penalty in almost 46 provisions under various laws. So for this 46 provisions, death penalty can be imposed in India. And this makes or gives a higher scope for a judicial error. So any kind of judicial error will impact the law and order system and this judicial error can lead to bigger mistakes. Like for example, the death penalty can never be revoked once it is implemented. So this 46 provisions under various laws in the country gives higher scope for a judicial error. And if we look at the history, Dr. B.R. Ambedkar argued for the abolition of death penalty. But the Constituent Assembly left the issue to the Supreme Court and the Parliament. So while making the Constitution or framing the Constitution, Dr. B.R. Ambedkar was against imposing death penalty. But the Assembly had left this issue to the Parliament and to the Supreme Court of India. And eventually Parliament and the judiciary could not abolish the death penalty that is in existence since the colonial times. And according to the 35th report of the Law Commission, which was in the year 1967, the Law Commission recommended for a retention of the provision. That means the provision of death penalty should be retained. And the new Code of Criminal Procedure, that is in 1973, required special reasons should be given if death penalty was imposed. That is, if death penalty has to be imposed, there should be some special reasons. But earlier, according to the old CRPC, which was in 1898, reasons were to be given if death penalty was not imposed. And this requirement was abolished in the year 1955. So, till 1955, if death penalty was not imposed for a crime, the reasons has to be mentioned. But in 1955, this clause was removed, and from 1973, from the new CRPC onwards, special cases or special reasons needs to be given if death penalty has to be imposed. And recently, according to the 187th report of the Law Commission, which was in 2003, the Law Commission recommended the use of lethal injection in addition to hanging. So this is briefly about the death penalty in India. And now moving on, let us understand how did the code stance evolved. Now in 1972, the Supreme Court upheld the constitutionality of death penalty. That means the Supreme Court confirmed that death penalty is constitutionally valid, and it stated that Article 14 on right to equality. So Article 14 of Indian Constitution talks about right to equality. And in 1972, when the Supreme Court upheld the constitutionality of the death penalty, it stated that right to equality under Article 14 of the Constitution is not violated by wide judicial discretion given by the judges. But in 1974, in another case, the Supreme Court said that the question of death and life cannot be left to ad hoc mood or individual discretion. That means the individual discretion of a judge cannot determine the life and death of a person. So it means that it ruled against death penalty. Again, in 1979, the Supreme Court rejected retribution or revenge as the purpose of punishment. So under this case, Supreme Court said that special reasons for the award of death penalty should be related to the criminal, not to the crime. So here Supreme Court said that a crime can take place under various circumstances. So the crime should not be the special reason, but the conduct or the background of the criminal should be the special reason for awarding death penalty. Now again in 1980, in the Bachchan Singh case, the matter was referred to a constitution bench of the Supreme Court, and the constitutional bench of the Supreme Court upheld the constitutionality of death penalty in the ratio 4:1. So out of the 5 members, 4 members supported that death penalty is constitutionally valid and 1 member was against this. So again in 1980, in the Bachchan Singh case, the constitutional validity was upheld by the Supreme Court. And in this case, the Supreme Court said that the special reasons for awarding death penalty should relate to both crime as well as the criminal. Earlier in 79, Supreme Court said that the special reasons should relate to the criminal, not to the crime. But here Supreme Court said that it should relate both to the crime as well as to the criminal. And among the 5 judges, only 1 judge was against the death penalty, and he was Justice P. Bhagwati. So here Justice P. Bhagwati, in a minority opinion, said that death penalty is arbitrary and discriminatory, therefore it is unconstitutional. So this was the opinion of Justice P. Bhagwati. Again in 1983, the Supreme Court upheld death penalty by hanging as constitutional, and the Supreme Court observed that it does not involve any humiliation or torture. So death penalty by hanging is constitutional and does not involve any kind of torture or violation of rights. Again in 1995, the Supreme Court held that hanging beyond a point of death by half an hour is unconstitutional. Now, from all these observations, what we understand is that there is no uniformity of precedence in terms of awarding death penalty, and also the death sentencing has become judge-centric. That means it is the discretion of the particular judge whether to award a death sentence or not. So it has become judge-centric, and also there is no uniformity in the precedence. Now coming to the established standards in case of imposing death penalty, first we will understand Machi Singh case, which was in the year 1983. So in 1983, in Machi Singh case, a 3-judge bench listed some parameters to decide whether a case falls under the category of rarest of the rare, because death penalty is awarded in case of rarest of the rare cases. So certain parameters were evolved, and this included the manner of commission of crime, like if the crime is highly brutal in nature or antisocial in nature, etc., the magnitude of the crime, the personality of the victim, etc. So these were some of the parameters that were evolved out of the Machi Singh case. So we will understand that these parameters or these categories put an emphasis on crime and not the criminal. So focus was given on the nature of the crime. So special reasons would be related to the nature of the crime. Now later in Bachan Singh case in 1980, and later in Bachan Singh case, the court upheld that a conscience of society test determines the judicial discretion. That means the rarest of the rare doctrine is not valid. So it is the conscience of society that determines whether to award a death sentence or not. Now when we understand the recent case, which we discussed in the beginning of this lecture, we have seen that the 3 courts, one Sessions Court, the High Court of Bombay and the Supreme Court. So 3 of these courts were unable to spot the illegalities by the investigating authorities, and the investigating authorities had framed crimes against 6 people. Now Supreme Court has reviewed this, and Supreme Court found out that they were innocent, and now the death penalty or the punishment have been revoked and they are acquitted. So this points out to a judicial error, and we need to rethink whether Indian criminal system or criminal justice system should continue to impose death penalty, because there is no scope for a revocation. And it would be too terrible if a person has been hanged for a crime which he or she has not committed. And such type of judicial errors affects or impacts the integrity of the judiciary. So imposing death penalty needs a serious revision in the Indian context. You can find the PDF of this lecture on my Facebook page, and for any queries regarding your preparations, you can get in touch with me on my Facebook page, or you can email me at joycey.studyiq@gmail.com. Thank you.